May I plead your lordship? My lord, I beg to mention item number 13, my lord.
Item number 13.
No, my lord, 13, my lord. Adjournment, my lord.
Item number 13.
Yes, my lord.
13. Yeah, what
yes.
do you want?
Here, my lord, additional, here, my lord, Advocate General will appear, my lord, in this matter, my lord. So may I pray that this matter may be listed after 2 weeks, my lord.
What is it about?
This about my lord. They have challenged, petitioner have challenged the,
Here we have challenged the Rule 5 of the Arunachal Pradesh Food Security Commission matter, Act matter, rules matter, framed under the National Food Security Act matter.
Yeah.
That rule has been challenged, madam.
What was the basic challenge for that?
Because, my lord, the under section 17 of the National Food Security Act, my lord, it
Yeah.
provides that the salaries of the State Food Commission, my lord, should be paid by the state government, my lord.
Fine.
Here, they have framed a rule, my lord, after our appointment, my lord,
What,
as a chairman of the State Commission, my
what
lord.
they have provided now?
They have provided, after appointment, they have framed a rule, my lord, under
Yeah.
section 40 of the National Food Security Act, my lord, whereby, my lord, our pay has been, without giving the salaries, my lord, they have, my lord, framed a rule, my lord, whereby, my lord, parks and revenues are made available to us, my lord.
Only
Which
perks
is-
and revenue, no salary.
No salary, my lord, only fixed amount of 40,000, my lord.
As per that 2007 the Food Security Act,
The salary is to be paid to us, my lord. Not, my lord, honorarium, my lord.
after 2 weeks, my lord.
2 weeks.
Yes, my lord.
At the request of the council appearing for the state, place this matter for after 2 weeks. Yes.
Members, I'd like to mention item number 14.
14.
14, 1 for 14.
Yeah.
From the petitioner said. Leading counsel say he's got some health issue, Your Honor. So he cannot appear today. Kindly the matter may be fixed after 2 weeks.
Adjourn.
Yeah, Your Lordship. I beg to mention item number 11, Your Lordship.
Yeah.
The leading counsel C. Modi, Your Lordship, is out of station due to his personal difficulties.
Where is gone?
He is in Pasigat now.
Pasigat.
Yes, sir.
The list was already prepared. Why you people are not arguing the matters? Yeah. At the request of council.
Your Lordship, may I mention item number 12? The leading counsel has scheduled, he went for admission of his son.
Where he has gone?
He went for admission, counseling for medical admission of his son.
Medical admission. He himself is.
No, his
seeking
son,
admission.
for his son, for
For
his son.
his son.
Yes,
Where he has gone?
he is from Guwahati.
Where?
Guwahati.
Guwahati.
Yeah.
Guwahati. I have come from Guwahati only.
But he went for his counsel.
And council has submitted that concept for the appellant. It's out of station due to some personal work. Matter may be adjourned. Adjourned.
All right.
Have you filed that inquiry report?
Yes, my lord.
Where is that?
My lord, it was filed on 3/6/24, my lord.
3624.
Yes, my lord. That's for the. It's a short affidavit. It is. As an additional affidavit. date of filing is from
Whether you are in receipt of this inquiry report?
Yes, Lordship. And accordingly, the main conducting council has directed me to inform this honorable court that he is contemplating to counter reply the inquiry report.
So,
Yes, sorry, sir.
start of it,
Sorry in this regard, Lordship.
for whom you were waiting for that? You should have mentioned it earlier.
Yes, sorry for that, Lordship.
And then the AG has submitted that the inquiry in the matter of issuance of land possession certificates to various persons, comma, which are being questioned by the petitioner, comma, has already been conducted, and the inquiry report is placed on record through an additional affidavit filed on 3/6/2024. Learned AG has submitted that as per the inquiry report, there is no illegality in issuance of land possession certificates and the NOCs in reserve forest areas of Namsai. And the same is, and everything has been done in accordance with law. The net consent appearing for the Mr. So-and-so, consent for the petitioner, has on instructions has submitted that the petitioners shall file and counter to the additional affidavit dated 3/6/2024 filed on behalf of the state. And he placed some place for time period for is granted when
Lordship, after 3 weeks, Lordship.
just after 4 weeks.
Lakshmi.
Yeah, please.
Yeah.
This is state appeal filed by the state government also. Here also the just for brief is here also. The read petitioner is also constable survey in AAPBN law. It's a Honorable Pradesh Police Battalion also. He was posted at the headquarters base at Chimpur, Itanagar. While walking there also, he encroached over the lane which was allotted to the BN itself. Accordingly, departmental proceeding was initiated, and ultimately 2 increment was reduced also. On
Learned single judge
No.
has ruled in favor of the private respondent on the ground that the rule which was taken into consideration for imposing penalty was
Correct.
not at all in existence.
loss. Losses take losses because that part losses in affidavit in opposition losses. File in the read petition.
Yeah,
That part has been losses explained losses. How that commission
that part has been explained.
explained, and that has not been considered by the learned single bail. That's my ground was.
Just a minute. There is an admission on the part of the state council before the learned single judge.
No admissions.
There is admission, come to this para number 5 of the impugned order of the learned single judge. Mr. Y. Ram, learned
Paragraph 5,
advocate submitted that it is an admitted fact that the provision of law mentioned in the impugned order is non-existent law.
Lordship, to understand this lordship, kindly come to page lordship.
But the fact remains that the petitioner has been under occupation of the land allotted to the sentence commission, the impugned orders should stand. On what premise?
Lordship, kindly come to page 31 lordship.
31.
31 lordship. Which was under challenge in the read petition lordship. in order in the writ petition.
Just 31. Yes, 31.
31 lawsuit, annexure 8 lawsuit. If I take lawsuit to the next page, that is 32 lawsuit,
32.
32 lawsuit.
Yeah.
And down below lawsuit, therefore, in compliance with the opposite court order, following order are passed. The act of unauthorizedly occupying a plot of government land by so and so, which is under positions of the commandant past APBN since 1989 as per government order so and so, amounts to misconduct under section 6 rules so and so, CSS conduct rules lawsuit. Here lawsuit in CSS rules lawsuit, section 6 is not their lawsuit.
Then
But this part has been explained in our affidavit in opposition
how
lawsuit.
you have explained?
Lawsuit, kindly come to page 135 lawsuit. My affidavit in opposition lawsuit.
135.
135. Relevant is 8 page 145. 145.
145.
140. Paragraph 22 lawsuit.
Paragraph 22.
22.
Yeah, read.
With regards to so and so made in so and so, the answering response not admitted and denied. It is submitted that, in fact, the commandant so and so, while passing orders dated so and so, relied on the so and so conduct omissions which amounts to misconduct of Chapter 6 conduct rules of SOMI Handbook for Central Government Staff, Mutusavi and so and so. Here, lawsuit in this handbook lawsuit, this particular chapter lawsuit, it contains lawsuit the list of the what amounts to misconduct lawsuit. Actually, it has been lawsuit while passing order that omission has been done lawsuit.
No, show us.
And then kindly come to page lawsuit, page 151 lawsuit.
151.
151 lawsuit. This is the lawsuit conduct rules.
Yes. Yeah, 151 conduct rules.
Conduct rules.
Yeah.
This is a SOMI handbook. The exact copy from the SOMI handbook.
Fine.
If I take lawsuit to the next page, there's 152 lawsuit.
152.
Yes, lawsuit. Down below lawsuit 2, acts, conduct and omission which amount to misconduct lawsuit.
Fine.
If the act or the conduct is prejudicial or likely to prejudicial to the interest of the master or to the reputations of the master lawsuit. If the act or conduct is inconsistent or incompatible with the due on peaceful discharge of his duty to his master. If the act or conduct of survey makes it unsafe for the employer to retain him in service. If the conduct or if the act or conduct of the survey is so grossly immoral that all reasonable men will say that the employee cannot be trusted. If the act or conduct of the employee is such that the master cannot rely on the faithfulness of his employee, at 11 lawsuit, willful disobedience so and so and so, this 12 lawsuit, infidelity, unfaithfulness, dishonesty, untrustworthiness, theft, fraud, dishonesty in connection with the employee's business or property loss. Here, lawsuit, what authority did is the conduct of the petitioner comes under this lawsuit definition lawsuit. Because he has encroached his own master's lawsuit lane, which has been allotted to the APPBN for establishment of headquarters. And headquarters is already established there, and he was posted there also. Here is what I'm submitting in lawsuit is a mere lawsuit, wrong reference of the provisional lawsuit. Otherwise, lawsuit in statute lawsuit, that source of power is traceable lawsuit.
So there was a direction for any order issued to him to vacate the land from that. The land which was he was illegally possessing or trespassed.
No,
Any notice to him that remove your occupation from the land or what?
Let's Lordship, as far there's no records here, Lordship, in the appeal, Lordship.
And what is his reply to the inquiry during the course of inquiry, whether he has admitted that or what?
Lordship, that has been admitted, Lordship.
Where is that?
Lordship reply. Kindly take up one additional affidavit, Lordship. In sequence, Lordship, file one additional affidavit.
Additional affidavit, when you have filed this additional affidavit?
It was Lordship filed on 22nd December 2023, Lordship.
Yes.
Kindly come to page 9, Lordship.
9.
Lordship.
Yes. Reply to the memorandum of
Reply to
articles.
articles.
Yes.
Regarding the land allotment, I am not denying that the APPBN has not have a allotment, land allotment. But regarding the questions of selling of tree, I'm sorry, Lordship. This particular departmental proceeding is the offshoot of the past departmental proceeding, Lordship. This is in reply to the past departmental proceeding, Lordship.
First departmental proceeding.
Proceeding, because here, Lordship, when this highway was constructed, Lordship, the part of the lane was, Lordship, that was acquired by the highway authority, Lordship, and lane was constructed, Lordship. During that, certain tree was fell down, Lordship, by the highway authority. The petitioners hold that tree to some other person, Lordship. Accordingly, Lordship, action was
That
initiated.
inquiry was conducted in.
That inquiry was conducted, and it was because charge could not be proved, so that was closed with observation, Lordship. Since he is in illegal possession of the land, so therefore another departmental proceeding can be initiated. On basis of that, another departmental proceeding was drawn.
That another departmental inquiry, whether he has filed any reply to the memorandum of article or charges.
Lordship. That reply also is here, Lordship.
Where is that? First of all, you show us this article of charges.
Article.
Memorandum of articles. In relation to the second inquiry.
Lordship. Page 35, Lordship.
35.
Page 35. This is a memorandum, and on next page, Lordship, Article 1.
Yes, what are the charges? Ignition of the payment level located in the time. The underposition of the square What is the inquiry report?
Inquiry report is 8 page lordship, 46 lordship. Page 46. Also may see page 49, that's a repetition filed by the petitioner in respect of the inquiry report.
49?
49 lawsuit.
Yeah,
In 49 lawsuit, he has admitted lawsuit.
what is that?
Page 49 lawsuit, if I paragraph second onwards. This is a
Undersigned begs to state that the very inception during undersigned was appointed and we had no good of it. In as much he was unaware of the purported land allotment order dated issued in favor of your esteemed good office.
Yes. Rather, understand based to state that initially the alleged plot of land was no man's land. As such, no one was in occupations upon the said plot of land. Thereafter, accordingly, the undersigned started his occupation hereby. It was establishing a kitchen garden as well as several plantations was started upon the alleged plot of land without any intervention from any owner. Not even your esteemed office has also raised any objection.
So this notice upon the other side has already been served?
Lawsuit. Already. And
Yes.
in next page, Lawsuit will find in the second paragraph.
Yes.
In nutshell, undersigned begs to submit that although he is not legal owner of the alleged plot of land, neither he is claiming the same, but whereas he is containing his plea that the said plot of land was under his possession since 1984 without any interference.
Who is appearing for the other side?
Me, my
You are appearing.
lord.
Yes.
My lord, my submission, my lord, will be start, my lord. The departmental inquiry, my lord, itself was initiated on non-existent ground, my lord.
What
And,
non-existence ground? Which non-existent ground?
In the sense, my lord,
There is
initiated.
no such rule 6 to 11 in
Yes,
the
ma'am.
CCS conduct. Rule.
Additionally,
Apart from that, is there any provision under this conduct rules under which you can be, if a person is in illegal occupation of the land belonging to his employer, can be punished or not?
no, my lord, that is not exist, my lord.
That is not.
And law does not allow subjective
Okay.
evaluation of
Okay.
the provision which
Show us that the land belongs to you.
My-
Any document
my lord,
that the land belongs to you. Show
My lord.
us any government document that you are.
page number 122, my lord, will kindly see, my lord.
122. Where is that 122?
In appeal, my lord.
Yes, what it says?
Appeal, my lord. This, my lord, this serial number, my lord,
122.
2, my lord.
Yes.
This is part of the compensation assessment, my lord.
What do you mean by compensation? Show us the ownership document. Maybe compensation have been granted to you. They have not even after paying the compensation, they have not acquired the land.
Yes, my lord.
Show us any land document which proves your ownership over the land in question.
To that extent, my lord, I humbly conceded, my lord, in our state of Arunachal Pradesh, my lord. Normally, my lord, until and unless someone, my lord, go for, my lord, some business purpose, my lord, there we do not normally does not obtain any, my lord, land documents, my lord, like patta system in Assam, my lord.
Normally people don't obtain.
Yeah, normally, normal.
But when you are facing this inquiry, you should have applied to the government for giving you the certificate or ownership certificate or title document or whatever it may be.
No, my lord, that way, my
Rather,
lord,
in your reply, you have admitted, I was not aware that this land was allotted to the whatever the appellant department. You admitted it.
my lord.
You admitted it. Sir.
Yes, my lord. Now, my lord, my humble submission, my lord. Here is a case, my lord. The submission that, my lord, this lane, my lord, allotted to the
Department.
police department is also not true, my lord. On the report,
This is true, sir. The land officer has given his statement in the.
that is their statement, my lord. State of police, my lord. But the lane belong in the state of Arunachal Pradesh, my lord. Lane belong to the land department, my lord.
Oh, even you are a police constable,
My lord.
and if you are encroached over the government land, that is expected from a disciplined force, a member of a disciplined force.
No, my lord. My humble submission, my lord.
Yes.
That my case is, my lord, death lane, my lord. Before my lord, this settlement there, my lord. This is this particular lane, my lord. Area, my lord. Area in outskirt of this capital city, my lord. Now, when I come here, my lord, I occupy dead lane, my lord.
Under what authority any government land lying in the this state, so any person can occupy that?
No, my humble submission, that is not the government land, my lord.
So whose land was this?
My lord, this was never donated to the government, my lord. This land belongs to whom? To that extent, my lord, that's why, my lord, kindly see my contention, my lord. I say, my lord, that land I purchased from one person, my lord, in the year, my lord, will kindly see, my lord.
You purchased.
Yes, my lord.
Where is that deed? Purchase deed.
No, my lord, that's why, my lord, will kindly appreciate, my
How
lord.
can you acquire a title without there being any deed? You have purchased the land from whom?
My lord, that
The
in,
person who was not the owner.
no, my, that is, he's not, to that extent, my lord, about the civil dispute, my lord. The suit, title suit is going on, my lord.
I am the owner of this the book.
My lord,
Suppose I am the owner of the book
my lord,
and I am giving you this book,
my lord,
selling you this book. You are purchasing this book.
my lord.
For that purpose, I should be the owner of the land,
My lord, that is true.
owner of the book.
True.
Otherwise, how can I hand over you this book if I am not the owner?
Yeah, my lord. For me, my lord, true, but my lord will dealing a situation, my lord, of the 1970s, my lord, in the state of Arunachal Pradesh, my lord. In the 1970s, normally there cannot be there was no said it
So
as
in
such,
the
my lord.
1970, it is free for all. Anybody can go and acquire any land lying in the state of Arunachal Pradesh.
No, my lord,
It seems that-
by purchase, my lord, that can be, my lord, and by occupation also, my lord.
So where is your pass?
That's why, my lord, my humble say, my lord, kindly have a look at some documents of this case, my lord. This, my lord, their contention that, my lord, this was allotted to them also is not true, my lord, because, my lord, there is a survey by the deputy commissioner, my lord, land department, my lord, and they saying no, this was not allotted to the police department, my lord. This is on the record, my lord. Now,
Even though if it is not allotted to the police department, whose land was this? How you came into occupation of that land?
that I have explained, my lord, my lord,
Where you explain? You simply said I was not aware and it was a no man's land. Therefore, I occupied that land.
my lord will kindly.
Since I am in occupation of the land since 1994, nobody has questioned me.
Yes, my lord.
Therefore, why now questioning me?
No.
This is what your tenor of your reply to the
My-
disciplinary proceeding.
My lord, my lord. Now, my lord, that it is addition to my lord, that is my reply to the police, my lord. Now, my lord, my humble submission, my lord. Even assuming, my lord, this there is a serious title dispute between me and my employer, my lord.
Yeah.
Now, my lord, for that, my lord, to be come under department inquiry, my lord, to come under the definition of misconduct, my lord, that should be precise in the rule book, my lord, in the CCS rule, my lord. That should be precise, my lord. This dispute, this conduct will become under the misconduct, my lord.
This conduct comes in the misconduct on several heads. In this chapter 6, part 2.
No, my lord.
Several heads.
My lord, kindly look at this, my lord.
Unbecoming of a government servant.
No,
Occupying a government land, trespassing over a government land. Certainly, it's unbecoming of a government servant.
No, my lord,
How
kindly.
you can expect a government servant can trespass the government land?
No, my lord. My humble submission, my lord. This is not government land, my lord.
Then
This
whose land is this?
I say this is my land, my lord.
Where is that title? Show us the title. If the land belongs to you, show us some document.
Yes, my lord. For documents, my lord, that is not there. That's why we have
nothing.
file.
Sometime you are saying that it was a no man land, so you occupied that land. Sometime you are saying I purchased this land from another person. Who was that person? How he was that? How that person was the owner of the land?
My lord, that way, my lord.
Okay, I will hear you. Okay, okay. This writ appeal is filed by the state, being agreed with the impugned order dated 2nd of February 2023, passed by the learned single judge in writ petition number 205/2022, whereby the learned single judge has allowed the writ petition filed on behalf of the private respondent and has set aside the order dated 26/5/2022, passed by the commandant, first AA PB and BHC BHQ Chimpu Itanagar, imposing a punishment of withholding, what was the punishment?
2 increment, my lord.
Of withholding one increment with cumulative effect, that is from 14 to 2019. Full stop. The learned single judge has interfered with the punishment order on the ground that in the punishment order there is a mention of section 6 rule 2 in brackets second of CCS conduct rules. However, no such rule exists in the CCS rules. Full stop. The learned single judge has not taken into consideration the merits of the charges as well as the evidence available on record, whereby the disciplinary authority has while relying on the inquiry report of the inquiry officer has imposed punishment upon the private respondent. Full stop. Learned concept for the state has submitted that though it is an admitted position that no such provision as such section 6 rule 2 second of CCS conduct rules exist in the CCS conduct rules. However, however, as per chapter 6 part 2 of the CCS conduct rules, the conduct of the private respondents very well comes within the definition of misconduct, and the disciplinary authority while imposing the penalty has wrongly mentioned chapter 6 as section 6 of the CCA conduct rules. It is argued that it is well settled that if a authority has the power to do an act under the provisions of the rules, non-mentioning or wrong mentioning of the provision of a rule will not make a order illegal. Full stop. Learned concept for the appellant has therefore submitted that the learned single judges erred in interfering with the punishment order passed by the disciplinary authority against the respondent. Full stop. Per contra, learned counsel appearing for the respondent has supported the impugned judgment passed by the learned single judge and has submitted that when no such provision under the conduct rules exist, the disciplinary authority has erred in imposing punishment relying on such non-existent rule. Full stop. On a pointed query by this court, learned counsel for the respondent has failed to submit any proof regarding the ownership of the land which is allegedly being occupied by the private respondent without any authority of law. Full stop. Having heard the learned counsel for the parties, we are of the view that matter requires consideration, hence admit issue notice. However, since the private respondent is represented through the advocate, no formal notice is required to be issued. In the meantime, effect and operation of the impugned order passed by the learned single judge shall remain stayed. This matter for final disposal in the month of November 2024.
I have humble clear, my lord. My lord, as this, my lord, DE, my lord, affecting my service career, my lord. My humble submission is, my lord, is the state opinion order, my lord. If my lord, please to hear the matter day after tomorrow, my lord.
Day after tomorrow, it's not possible, sir. We'll hear it in November. Yes.
Lord, I appear for item number 3,
Yes,
virtually.
excuse me, IA number.
IA 85 is for stay of the laws.
Interim order.
If that part can be, say,
IA is disposed. Yes.
My lordship, I beg to appear virtually for item number 3, my lord, for the petitioner.
Yeah.
My lord, this petition is filed and against the order passed under GST, my lord. But now the main issue in the notice is covered by the latest amendment of the Finance Act 2024, my lord.
That
colleague will
this finance, where is that amendment?
My colleague will pass on the relevant extract of the section, my lord.
Yes.
Section 118 of the Finance Act, my lord.
Yes, which is that 16(4), which provision is there? And this new provision has been added?
Yes, my lord.
Yes, my lord.
Subsection 5, my lord. Subsection 5.
Subsection 5 to section 16(4).
Yes, my lord.
Not saying anything contained in subsection 4 in respect of the invoice or debit note for supply of goods or service or both pertaining to the financial year so and so, that is there.
Yes, my lord. Yes, my lord.
Tax any return under section 39, which is filed up to 13th day of November 2021. So your client is coming in this date of November 2021.
Yes, my lord.
Yes, my lord. Date now.
Look here, learned counsel for the parties are in agreement that in view of the insertion of subsection 5 in section 16 of the Central Goods and Service Tax Act 2017, the grievance raised by the petitioner in this writ petition has been redressed. Full stop. Para. Section the section 16(5) of the Act of 2017 reads as under. Now this code this. Stop. Since the parties are in agreement that the grievance raised by the petitioner in this writ petition is redressed by insertion of section 5 under section 16 of the subsection 5 under section 16 of the CGST Act 2017. No further order is required to be passed in this writ petition. The same is therefore disposed of. IA number so and so. If any IA is also disposed of.
Obliged.
Highly obliged, my lord.
May I please, your lordships? This matter relates to shifting of stone crushers from the some of the on the river sides and some are in the garden areas. But in this matter, respondent number 2 and 9 and 10 have filed affidavit.
2 and 9.
2, 9 and 10.
2, 9 and 10.
Yes, my lord. And we have taken step to respondent number 3 through Dusty, and we have filed the affidavit of service, my lord, on 2nd of August 2024, my lord.
2nd
of August.
Fine.
Yes, my lord.
Now
And rejoinder, we want to file. Your lordship may allow.
Rejoinder to reply of whom?
2, 9 and 10.
Only, not respondent number.
They have not filed yet, my lord.
They have not filed yet.
3, 4, 5,
Okay,
6.
concept of the petitioner prays some time to file counter to the reply affidavit filed on behalf of the respondent number 2,
9 and 10.
9 and 10.
Yes, ma'am.
Time period for is granted list after
2 weeks.
2 weeks.
Obliged.
Your Lordship, on the last occasion, legal aid counsel was to be appointed.
Who is appearing as a legal aid counsel?
My lord, I am for the respondent numbers, respondents as a legal aid counsel,
Then
legal aid counsel for respondents.
now
Your lordship may fix this matter for hearing, your lordship. Otherwise, we have also received the paper book.
देखिए, this writ appeal is already admitted on 27/6/2023 and pursuant to the direction given by this court. Legal aid counsel for respondent number 2 has also been appointed. It stop. Learned counsel for the parties have submitted that the matter may be, that this appeal may be listed for hearing. Stop. Having heard the learned in view of the request made by the counsel for the, but who is appealing for the petitioner?
Your lordship, an amicus curiae was appointed, your lordship. I have just received a phone call this morning. Amicus, I'm for the state additional
Okay,
PPA.
what the amicus is?
Your lordship, she had just called this morning having some medical issues. She could not attend the court today, your lordship.
No, explain, but then the appeal is already admitted on so and so, and pursuant to the order passed by this court, the amicus curiae on behalf of the respondent number 2 has also been appointed. Full stop. Learned counsel, state counsel has submitted that the amicus appearing on behalf of the appellant is not available on account of some health problem, and therefore she prays that matter be listed for hearing in due course.
Yes, medical course.
Full stop. In view of the above, let this appeal be listed for the hearing. Yes.
Lordship, there is a serious irregularities in conviction order, Lordship.
Conviction order have been issued.
Yes, sir. It's a criminal appeal challenging the conviction under POCSO Act, your lordship.
Return of notice for 2 more weeks.
That's, yeah, you can.
Instead of issuing fresh notices, we'll await the return of the
Yes,
notice. Await return of notices of the respondent number 5, 6, and 7 for 3 more weeks.
Motion.
May I please, Lordship? Lordship, I humbly pray, Lordship, IA may be allowed for the hearing today, Lordship. This is
You are for
suspension. I am for the Lordship appeal and Lordship.
suspension of sentence applications.
Yes, Lordship. Paper book is received.
Why don't you argue?
Lordship.
Why don't you argue?
Lordship, this is Lordship, FIR has lodged. May I please, Lordship?
You have not seen the file?
Yes, I had filed, Lordship.
No, you have gone through the record or what?
Yes, yes, Lordship. I go to the record.
So the allegation against the appellant of killing her husband.
Yes, Lordship, yes, Lordship.
What is?
And complaining is Lordship, her son, Lordship.
Yeah.
Yes, Lordship. May I read the
Are you
FIR?
prepared?
Yes, Lordship.
You are prepared?
Yes, Lordship.
Okay then.
May I please, Lordship? Lordship, FIR has Lordship, lodged 9 July 2022, Lordship.
9 July 2022.
Yes, Lordship.
Where is
And
the FIR?
FIR copy is, Lordship, in paper book, Lordship. Page number 1. Page number 1, Lordship.
This one, this one.
In IA, Lordship, page number 31, Lordship.
Page
FIR
1?
copy. Page number 31, Lordship. And 32 is 31 is type copy, Lordship.
31.
In IA, Lordship. In paper book, page number 1, Lordship, and IA page number 31, Lordship.
No, the paper book. Where is the FIR in paper book?
Paper book is page number Three lordship. Sorry, lordship. Here,
Page
lordship.
number one is the FIR.
Yes, lordship. Here, lordship.
Hmm?
Page number 3, lordship.
Yeah, that's right.
Yes. May I read the FIR copy, lordship? I beg to inform you that my mother, Srimati Murkya Papa, attacked my father, led Joting Papa, with a peer and a Meche Dao at around 2 a.m. on 9 July 2022, due to which my father died. The incident happened in my house located at Changyang camp. There in this FIR, lordship, and there have a deposition, lordship. It was happened, lordship. And regarding that 161 statement of the PW3, lordship, PW3 is a Deepa Pafa, lordship. He is a neighbors of Murkya Pafa and Joting Pafa, both. And that, lordship, at the night, lordship, there have unnatural sound was there, lordship, like some very hardly.
This Kama Papa is the daughter of that
Son of
the
deceased and
the
accused, lordship.
accused.
Yes, lordship.
He is examined as
He was exactly, lordship, at that time not play. He was Sepa town, lordship.
he was.
He was Sepa town, far from more than 90
Where is
kilometers.
his deposition? He is produced.
He is here in a PW8, lordship.
PW
8.
8,
7, your lordship.
PW 7.
Page number 27, your lordship. Statement is.
He is the complainant, na?
Yes,
Yes.
lordship. He is
The complaint. The accused, this is an appearance on the estate at Sepa, came to never killed my father. She might have not intentionally killed. She might have did the same as she was suffering from mental illness. After getting the information, when the police came in West, I was present there. Where is that? Who is the eyewitness in the matter?
Eyewitness, lordship, Deepa Pafa and PW3, lord. Start from PW3, PW4,
PW3
PW6.
and PW4,
And-
PW3, 4 and 6.
Yes, and 5 also, lordship. They all are a neighbor, lordship.
Just
Page number 22, lordship, in paper books.
just a
Page number 22, lordship. Deepa Pafa.
we go through, please.
Yes, lordship.
Yes.
Yeah, Lordship, according to this all the evidence, Lordship, that every Lordship eyewitness is denied, Lordship, they have they
Yeah.
yes, Lordship. Every eyewitness has Lordship deny Lordship. That
Every-
regard eyewitness Lordship PW 3, 4, 5, and 6 Lordship.
Eyewitnesses, they were not the eyewitnesses.
Yeah, yes, Lordship. And
They were
regard-
eyewitnesses.
And regarding that Lordship, that maybe Lordship, suspension of sentence may be allowed, Lordship. And Lordship, accused person is also mother of the 6th child, Lordship. That all the children are, Lordship, suffering from very difficult to survive, Lordship. And there have also one small child are also their Lordship, nearby 3 years, Lordship. So they have some care, Lordship. Even though, Lordship, nobody for perfectly care, Lordship. So difficulty is facing, Lordship. At least maybe few days or maybe any of the death, Lordship, suspension of sentence may be allowed, Lordship.
Only for few days.
After till date of the Lordship, final hearing, Lordship.
After?
Final hearing, Lordship. That my humbly prayed, Lordship, suspension of sentence may be allowed, Lordship.
On what ground?
The ground is that, Lordship, in regard this case, Lordship, all the evidence are to convict in the circumstances of evidence, Lordship, and that change is, Lordship.
Two witnesses, is one is PW, this PW5.
Yes, Lordship.
Fem Pafa, and this another is PW6.
Yes, Lordship. And that Lordship, Fema Pafa is a neighbors of the deceased Lordship.
No.
And that Lordship, it was informed by Lordship, Deepa Pafa Lordship, at the night, Lordship.
Yes.
Regarding that Lordship, she is also deny Lordship. I have not seen that.
No, they have not seen, but all the three witnesses, namely these PW, what is the name, that PW, Fem Pafa, PW5,
PW5 Lordship.
and these PW, another is this PW9. Not PW.
PW9 is
just
PW6, your lordship.
PW6
and
who is PW6?
PW6 is Lordship Ayang Pafa Lordship. He is also a neighbor Lordship. And sister-in-law.
Pafa resident wake up call, she signed after getting already Jatin. In certain the blood was disease was about, but he was not able to speak. We tied the this and this Fem Pafa. These are the two witnesses. How to disbelieve them? Why to disbelieve them?
That Lordship, according to the deposition Lordship, that I have in that cross Lordship, I have not seen the deceased killing by the accused.
Nobody
Lordship.
has seen the deceased killing.
Yes, Lordship.
But she was she had the persons, and therefore they tied her and called the police.
And there have also one conflict, Lordship, that Ayang Pafa and Deepa Pafa was informed to Ayang Pafa, Lordship. And that firstly, Lordship, to go to Deepa Pafa, Lordship. And secondly, come the Ayang Pafa, Lordship. And that may be, Lordship, their defect may be the changes of the evidence, Lordship. So that regard, Lordship, kindly maybe allow for the suspension of safety.
Yes, madam.
Yes, your lordship has rightly pointed out, your lordship, though there is no eyewitnesses, the circumstances is such that immediately after the incident, your lordship, these two were the first witnesses who has witnessed, your lordship. The second is the wife and the husband were all
What was
alone
the
in the
motive?
house. The motive, if your lordship will find at a statement of the IO, your lordship.
He has not investigated on this point that he was having some illicit relationship.
No, the only,
She was having illicit relationship, she was, though she was killed.
but he has investigated and there was nothing, any evidences to prove that. The only reason given was that. Otherwise, they have also,
The motive was not proved.
the motive was not proved, your lordship.
And it is also an admitted case that earlier also she attacked her husband
Yes.
on account of her marital illness.
Now, your lordship, they have tried to take the advantage of section 84 of IPC, your lordship, like general exception, your lordship. However, even in general exception under 84, your lordship, the accused has to prove that she was mentally ill, your lordship. In this case, though witnesses were also there.
2 years, 3 years old child.
Yes, your lordship. That I agree to. The last child is of 2 years of age, your lordship.
At that time.
At that time, your lordship.
She must be, he or she must be 4 years.
Yes.
Okay, the matter comes upon for consideration of the IN pursuant to so and so. Referred on behalf of the appellant seeking suspension of sentence awarded by the London trial court by judgment dated so and so, so and so. The trial court by judgment is also dated so and so has convicted and sentenced the accused for the offense punishable under so and so. Convicted the accused appellant for the offense punishable under section so and so, sentenced in the following manner. It's top. Learned concept for the appellant has submitted that the trial court has grossly erred in convicting and sentencing the appellant by impugned judgment. It is submitted that as a matter of fact, there is no eyewitness to the alleged incident wherein the deceased was killed, and merely on the basis of suspicion, the appellant was apprehended and put to trial. Learned counsel has invited our attention towards the statement, deposition of the eyewitnesses, and has submitted that all the eyewitnesses in their cross-examination has clearly admitted that they have not seen the appellant assaulting the deceased. The counsel has further submitted that the prosecution has failed to prove any motive of the accused to commit the crime. It is further submitted that as a matter of fact, the appellant has wrongly been framed, the appellant has been framed in the incident, though she has not committed the said offense. It is further submitted that the complainant, who is the son of the appellant, as well as the another's complainant was the son, na?
Yes, your lordship.
And the daughter and daughter of the appellant, who appeared as prosecution witness 1 and defense witness 1, has specifically stated that there was no quarrel between the deceased and the appellant, and therefore there was no reason for the appellant to commit the murder of her husband. to stop learned counsel has also submitted that the appellant has has kitne minor children, how many minor children you are?
Minor children, maybe one or two, Your Lordship.
Maybe or what maybe, what do you mean by maybe?
Lordship, one is here next year, Lordship. In one is Lordship, one 2021 Lordship.
And the others,
Other are some major Lordship.
all are major.
Yes, Lordship.
So should be prepared. Have the facts in your.
Yes, Lordship. Sorry, Lordship.
You should be prepared with the facts. You are seeking suspension of sentence, bail.
Yes,
You should be prepared. You are a young advocate. You should prepare all these things.
yes, Lordship.
Be ready with all the facts.
Yes, Lordship.
And concept of the appellant is further submitted that the appellant is having a minor children, daughter or son.
There have
Last
one daughter, Lordship.
daughter.
Yes, Lordship.
Madam, daughter.
Your Lordship, there is no reference in the paperwork, Your Lordship. Only the age was of 2 years during the incident. Your Lordship.
Think so. Is having a minor children of 4 years of age and is deprived of love and care of a mother. Stop. When it consent as per the submitted that. And then consider they portrayed that this sentence awarded by the London trial court may kindly be suspended. Stop. For contra, London counsel appearing for the state has vehemently opposed the application for suspension of sentence. Having heard the London counsel for the parties and after carefully scrutinizing the record, we are of the view that carefully scrutinizing the record, we are of the view that appeal preferred by the appellant on the conviction and sentence awarded by the trial court is based on strong grounds as the whole case of the prosecution rests on circumstance and evidence because no eyewitness, because no person has stated before, no witness has stated before the trial, as deposed before the trial court that he or she has seen the appellant committing the crime. Stop. On the ground of 25,000 something, 50,000. Personal bond of 50,000 and two sureties of 25,000 each.
May I, Your Honor?
Yes.
May I, my lord? My lord, I have been appointed as legal aid counsel for the convict. And as per the direction of this honorable court, I had filed appeal memo also. After that, she engaged private counsel, my brother as a private.
Fine.
So my name may be struck off as a legal aid counsel. In this case.
There are amicus curiae.
Yes, my lord. As a legal aid in order.
Just that though though in the jail appeal preferred on behalf of the appellant, Mrs. So-and-so was appointed as amicus curiae, but since a regular appeal is filed on behalf of the appellant, the name of the amicus curiae be deleted, be deleted from the cause list. You should make it then, and then. Yes.
Your Lordship, in the main appeal, Your Lordship, the main appeal, Your Lordship, that has also come, Your Lordship, item number 9.
Main appeal is admitted, not admitted.
Admitted, Your Lordship can fix this matter. The service is awaited on respondent number 2, Your Lordship.
Respondent number two services, why the respondent number two was made party?
They have made the respondent number 2 a party, Your Lordship, in the
Wait, in terms of this notices of the respondent number two
after 4 weeks, Your Lordship.
for 6 weeks.
Deeply.
Deem fatal.
This is an appeal against the impugn order dated 31/5/2023, passed by the Special Court, Khonsa.
Yes.
Yes, Your I was convicted only on the sole testimony of the prosecutors,
Victim.
victim. So here, Your Honor, may I draw your kind attention to the judgment? It's in page number 88 of the paper book.
Yeah.
Here the brief prosecution story of the case is that on 22/8/2021 at about 1640 hours, a joint written information was received from one Sri Buddhachadan Chakma and Natun Chandra Chakma to affect that on 1/8/2021 at around 1300 hours, the victim girl's age went to fetch water from the source.
These are the facts.
These are the facts. But thing is that whether these particular documents which they report as first information, is this a first information report? Is this exactly qualify? What is the provision there in 154? If we come to the page number 89 of the same judgment, it's para number 2.
Yeah.
May I read that? On dated 2/8/2021 at about 6:38 hours, the victim girls with swelling on eyes and face were brought to the police station in a van by the informant. The victim was reportedly raped and assaulted by an unknown person. So in that, here, if we go strictly with the section 154 of the CRPC, now the thing is that which one is to be treated as the first information report?
This is only one first information report. How you are claiming these are two first information reports?
Yes, because this is the in para number 2, they had this verbally victim went to the police stations and they had informed about the cognizable offense.
Yeah.
Now the thing is that the IO, the officer in charge of the police station, has instantly started investigation into this matter, which is evident from page.
Where is the FIR?
FIR is page number Your Honor, 1. 1. May I read? That's the top.
Yes.
Received on 2/8/2021 at 1640 hours and registered the Dayun PS case number 9 of 2021 under section 376, 307, 325, 201 IPC, read with section 4 of POCSO Act. I, Sri W. Tanha, has taken the investigations of the case. This is the noting made by the officer in charge at 1640 hours.
Yes.
Now come to page number 27, Your Honor, of the paper book. And only after registration of this FIR, he had assigned the number 27.
Yes.
This is the CJ memo prepared by the investigation officers. May I read that?
Yeah.
Dayun PS dated 10 time to 28/8 at 1400 hours. That is before the registration of the FIR at page number 1, which is exhibit 4. And they had even assigned a case number here.
What is the explanation of the this investigating officer?
He had not explained. He has simply said that I received the FIR, written FIR.
Have you cross-examined him on this point?
No, not.
Why? Then what is the point in raising this now?
Because he himself had
Have you
stated.
cross-examined about this discrepancy?
About this discussion, yes, a bit.
That how you mentioned this in this Caesar memo, timing is 14 hours, whereas the FIR itself or complaint itself was filed at 1640 years.
That particular question was not put
Not
directly.
put to them. What's the point in raising
But-
this ground here now?
But thing is that whether that will be counted as an FIR and as exhibit 4.
Sir, first of all, so you have to ascertain from that officer, okay, which is that FIR which you are received. That is the first FIR or second FIR?
That particular question was not.
That
put.
particular, then
That
until
particular-
and unless you ask them, how can we go into all this, sir?
That particular question was not put to him directly. But even though this is on record, Your Honor, this is on
Whatever
record.
it may be, but whether these point or even before the trial court, you have raised this point?
Yes, we had, because
Then
even in
How
his,
the trial court has dealt with it?
no, this point was not done with.
You have raised it.
Though it was oral submission was given, but
Yes,
it's
sir,
not-
oral submission, please don't do this. Oral submission, today you are making some submission and now in the appellate court, you may say, we have raised this objection or argument and not dealt with. Where is that?
even here in the examination chief, he had
So
stated.
go and examine it, whether the point which you are raising, you have not even raised
No,
before
it was not.
not clarified the same from the investigating officer or the person who has recorded the FIR, registered the FIR. What would be the effect of that, sir?
Was not put.
What would be the effect of that?
But he himself has stated.
You
That-
should have clarified from that person
But
that,
it do,
look, this Caesar memo, you have mentioned date here, Caesar memo at 14 hours. And now this FIR is of
1640.
1640 years. How you have started investigation before that?
That particular question was not put.
Not put to them. You have to clarify this, sir. Or you should have asked him. He should have clarified it. Okay, this was the reason we have done so and so.
At least it should.
It means the clarification was there and therefore you have not asked it.
No, here.
You are
also-
apprehensive that if I'll put this question to the investigating officer, he would clarify it. Therefore, you have not asked it.
But from the conduct of the investigation officers, he had
Sir,
initiated
for that
it.
purpose, you must have sought a clarification from it. And if he failed to give a clarification, then certainly you had a point. But since you have not asked him, it would be deemed that you are aware that he was having clarification for that, and therefore you have not asked this.
In that point, yes. Because since
You
I
are
had not
apprehensive
said
of this
direct-
fact that if I put this question to him, he would clarify it.
Yes. that-
What is the discrepancy? But you, and therefore you have not asked him.
But thing is, it was done by some other advocates in the trial stage. So that is
Not the
the
other
thing.
advocate, it is on behalf of we are not concerned with the advocates, it is on behalf of the accused.
So it is, sometimes they had missed it out because major things they had missed out. They had not put this question.
Then prepare this case on this aspect,
Okay.
then argue. Prepare on this aspect, and even though if you have not cross-examined
Yes, I
the
will.
relevant person, then also you can raise it, then we'll consider it. When?
And after 2 weeks.
Yes, ma'am. On 2/8/21?
No, timing is different.
To clarify, madam, Caesar memo mentioned the time 14:00 hours. And the FIR itself was registered on 16.40. How can it be? You have to clarify this. Not in every case. It
No.
depends upon case to case, not
But-
in every case. If there is lapses in the investigation, certainly the benefit of doubt goes to the accused person. You have to clarify this. Both of you have to clarify.
Yes, I will, because there is a citation wherein it says the fabricated documents comes deliberately after initiation of
Sir,
investigation.
Application के लिए how to prove that?
That I will come,
Must-
I will come with citation.
The request of land council for the, Nikhil and council for the appellant pays some more time to prepare the matter.
Can it be
This
placed
for
after
2
Puja
weeks.
vacation? Can it be on
Whatever
Puja?
the date, list
Twen-
on so and so.
20,
Choice, your,
28.
date is of your choice. Madam, date is of your choice. Whatever you want.